Okay, let's dive in. Think about rural New South Wales. Not just the land, but something even more vital, water.
Absolutely. Who gets it? How? And, crucially, what happens when the government changes the rules, seemingly overnight?
Yeah, and this isn't just some small local argument. It became this huge legal battle, a real saga that climbed all the way up to the High Court of Australia.
That's right. Coulton and others v. Holcombe and others.
And it wasn't just about the water itself in the end, was it? It became about, well, the rules of the game in court.
Exactly. It turned into this landmark case on legal procedure.
Yeah.
Like, can you keep a key argument in your back pocket during the trial and then, bam, hit your opponents with it years later on appeal?
A bit of a legal ambush attempt.
You could say that. And the High Court, well, they had some pretty strong views on whether that's fair play.
So our mission here is to unpack this whole tangled journey. We need to look at who is involved. You've got landowners, regulators, judges, the barristers arguing the points.
Right. We'll track how this fight over a river turned into a major statement on legal rules, full of, twists and turns. And a pretty surprising ending, too.
And the law at the center of it all.
It's the Water Act, 1912, from New South Wales.
Yeah.
We're talking specific bits like Section 10, that's for individual water licenses.
Oh, okay.
Then Section 20, that's for joint water supply schemes. Think groups of farmers wanting to share infrastructure.
Right. Group projects.
And the real flashpoint, Section 20Y, this gave the Water Resources Commission the power to basically say, okay, this water source is now closed for new applications. If they decided there wasn't enough water left after covering the existing rights.
So they can just shut the door.
Pretty much.
Yeah.
And that power, when they used it, is what really kicked things off.
Okay, let's meet the players in this drama. First corner, you have Keith Alfred Coulton and, wow, more than 100 others.
Yeah, big group. They already had water licenses. They were kind of the haves in this situation, trying to protect what they had. They were the plaintiffs, the appellants, the opponents at different times.
And their legal team initially.
They were represented by Mr. J.R. Dunford QC, that's Queen's Counsel, a senior barrister, and Mr. M.F. McDermott, also a barrister, instructed by the Crown Solicitor for New South Wales.
Got it. And in the other corner.
Alexander Thomas Holcombe and over 30 others. They were part of the Whalen Creek Water Users Association. They were the ones seeking new water rights, the have-nots trying to get access, specifically for a joint scheme.
So they were the defendants, the respondents, the claimants.
Exactly. And their legal team included another prominent QC, Mr. R.J. Ellicott, and Mr. M.G. Craig as barristers. Their instructing solicitors were Greaves, Wannon, and Williams.
Two QCs facing off suggests this was serious from the start.
Oh, absolutely. Then you have the regulator, the Water Resources Commission. Its name changed later, but that's who it was. They managed the water rights, and they ended up as defendants, too, usually represented by the Crown Solicitor's Office.
And briefly, the local land board.
Yeah, they did the initial public inquiries for license applications. They were also defendants early on.
So what was the specific event that lit the fuse?
It was a notice. Published in the NSW Government Gazette, 30th of July, 1982. The Water Resources Commission used that Section 20Y power we talked about.
Okay.
They declared that from that day forward, no more applications for licenses or authorities would be granted for a specific stretch of water. The Severn River, from the upper limit of Pindari Dam storage downstream to McIntyre River.
Why?
Because, they stated, they were satisfied there just wasn't enough water for new users once existing entitlements were met. So if you wanted water from there and hadn't already applied by July 30th, 1982, well, tough luck, basically.
Right. Which brings us to the Holcombe group, the ones seeking water. How did this notice affect them? They must have applied before that day, right?
Well, partly. They had put in an application back in August 1979, but that was for a Section 10 license, an individual one from the McIntyre River.
Okay, so pre-notice. That sounds fine.
But then, on February 4th, 1983, and this is the key date, it's after the 1982 notice, they submitted another application. This time it was under Section 20 for that joint water supply scheme.
Ah, so a different type of application, and definitely after the cutoff.
Exactly. But here's the twist. The Commission decided to treat this 1983 Section 20 application not as a new application, but as an amendment to the old 1979 Section 10 application.
Hang on. How can a group application from 1983 be an amendment to an individual one from 1979? They seem quite different.
That's precisely what the Coulton Group thought. The Commission went ahead, advertised this amended application, objections flew in, including from Coulton and his group, and it landed with the local land board for an inquiry.
So the commission essentially tried to backdate the 1983 application by linking it to the 1979 one to get around the 1982 notice.
That was certainly the effect, and the Coulton group cried foul. This led straight to court.
The first big showdown.
Yep. Coulton's group filed a summons in the Supreme Court of NSW, Administrative Law Division, on April 19, 1984. They weren't arguing about if there was enough water, not yet anyway. They were attacking the process.
What do they want the court to do?
They wanted declarations. One, that the 1983 application was invalid because it was made contrary to the Section 20Y notice. Two, that it absolutely was not an amendment of the 1979 application. And three, they wanted injunctions orders to stop the commission and the board from going any further with either application.
Okay, so the trial happens before Justice Lusher. What were the arguments? Coulton's side first, with Mr. Dunford QC and Mr. McDermott?
Their argument was straightforward. Section 10 and Section 20 are fundamentally different types of applications under the Act. The 1979 application, they said, was basically abandoned, never advertised, never pursued. It was dead in the water.
Okay.
Therefore, the 1983 Section 20 application had to be a new application. And since it was filed after the July 1982 Section 20Y notice, that notice simply blocked it. Kaput. They argued the commission had no legal power to just deem it an amendment.
Makes sense. What about Holcombe's side, with Mr. Ellicott QC and Mr. Craig? How did they justify the amendment idea?
They admitted the 1979 application wasn't advertised, but they pointed to discussions they'd had with the commission, and crucially, the fact that the commission itself processed the 1983 application as an amendment. Their whole case rested on linking the 1983 application back to 1979.
So if it relates back to 1979, it predates the 1982 notice and isn't blocked.
That was the core of their argument. If they could establish that link, the notice wouldn't touch them.
Now, this is really important, right? At this stage, at this first trial, did Holcombe's team challenge the validity of the 1982 notice itself?
No, absolutely not. That's critical. For the purpose of this trial, they accepted the notice was validly made. Their argument was purely about whether their application came under its scope or not.
And the commission and the board, the other defendants?
Likely represented by the Crown Solicitor, too, effectively siding with the Coulton group on the procedural point, perhaps, or at least defending the notice itself, though the main fight was between the landowner groups.
So, Judgment Day arrives. Justice Lusher, August 13th, 1984. What did he decide?
A decisive win for Coulton and his group. Justice Lusher bought their arguments completely. He emphasized the distinction between IS-10 and IS-20 applications.
Yep.
He found no legal basis for the commission treating the later one as an amendment of the earlier. He considered the 1979 application basically lapsed or abandoned.
And the consequence?
Because the 1983 application was made after the 1982 notice and wasn't a valid amendment, the notice did apply. It precluded the grant of the license, rendering the application void. He issued the declarations and injunctions Coulton sought, full stop on Holcombe's application via that path.
Wow. So round one goes clearly to the existing license holders, the Coulton group, based on the dates, the law, and the fact that Holcombe didn't challenge the notice itself.
Exactly. But, as you can imagine, this was far from the end of the story.
Holcombe's group wasn't going to just accept that.
No way. They appealed to the Court of Appeal in September 1984. Their notice of appeal had 17 different grounds, all attacking Justice Lusher's reasoning about the applications, the S-10 versus the 20 stuff,
Yeah.
the amendment issue, whether the 1979 one had lapsed, and so on. Still, Mr. Ellicott QC and Mr. Craig on the case for them.
Standard appeal stuff so far, challenging the trial judge's findings on the points argued at trial.
Yes. But then came the big twist. When the appeal hearing actually started, June 25th, 1985, before the Court of Appeal, that was President Kirby, Justice Hope, and Justice McHugh. Mr. Ellicott, for Holcombe, stood up and asked the court for permission to add a brand new ground of appeal, an 18th ground.
And what was this new ground? Let me guess.
You got it. The new ground argued that the original 1982 Section 20Y notice was itself invalid right from the start.
Whoa. The very notice they accepted as valid at the trial.
The very same one. They now wanted to argue the commission couldn't possibly have been legally satisfied there wasn't enough water, which was the condition needed to issue the notice under the Act. This was a complete U-turn.
That feels bold. To try and raise something so fundamental so late, and which contradicts your position at trial.
Extremely bold. And highly irregular in legal procedure. You generally have to raise your issues at the trial. Appeals are meant to correct errors made by the trial judge on the case presented to them.
So how did the Court of Appeal react to this request? Curdy, Hope, McHugh, JJ.
Surprisingly, perhaps, they unanimously agreed to let Holcombe add the new ground. This was in June 1985. They also gave permission to bring in new evidence related to this question of the notice's validity.
Why? Why allow such a late fundamental change?
Their reasoning was that there were special grounds or countervailing considerations. They pointed to the public law nature of the issue interpreting a statute, the powers of the commission. They thought clarifying the validity of the notice was important for the broader community and might even help resolve a similar issue in another case they had pending.
So public interest trumped the usual rules of procedure in their view.
That seems to be the gist of it. They opened the door for Holcombe to fight the case on an entirely new basis, challenging the very foundation of Justice Lusher's decision, even though they hadn't raised it before him.
This must have caused uproar on the Coulton side. They won based on the notice being accepted, and now the goalposts were being moved on appeal.
Exactly. And it set the stage for the next major clash, this time over the principles themselves. It went higher.
To the High Court of Australia.
Precisely. The Coulton group, presumably still led by Mr. Dunford QC and Mr. McDermott, instructed by the Crown Solicitor, weren't having it. They sought and got special leave to appeal the Court of Appeal's decision allowing the new ground.
So the appeal to the High Court wasn't about the water rights directly, but about whether the Court of Appeal messed up by letting Holcombe change their arguments so late.
That's exactly it. The core issue before the High Court was this fundamental principle. Can a party raise a totally new point on appeal, especially one involving facts, that they could have, but didn't, raise at the trial? Coulton argued it was unfair, unjust, and undermined the whole process. Holcombe, with Mr. Ellicott arguing, defended the Court of Appeal's discretion, emphasizing the public law angle. The Commission also chimed in with submissions.
And the High Court's verdict, this feels pivotal.
It was. On June 19, 1986, the High Court delivered its judgment, and the majority Chief Justice Gibbs, Justices Wilson, Brennan, and Dawson came down firmly on Coulton's side. Justice Dean dissented.
So they overturned the Court of Appeal.
They did. They allowed Coulton's appeal, set aside the Court of Appeal's orders that had allowed the new ground and evidence, and sent the case back down.
With instructions, presumably.
Oh, yes. Very clear instructions. The Court of Appeal was to hear Holcombe's appeal, but only on the original 17 grounds argued before Justice Lusher. The challenge to the notice's validity was off the table in this case.
Why such a strong stance? What was the High Court's reasoning?
They delivered a powerful reaffirmation of a basic legal principle. A party is bound by the conduct of his case. You make your bet at trial, you lie in it on appeal, essentially.
You choose your strategy and you stick with it.
Right. They said allowing a party to raise a new argument on appeal, when they failed to raise at trial, goes against fundamental principles of fairness and finality, unless there are most exceptional circumstances.
And the public interest argument didn't cut it for the High Court.
Not here. They felt the Court of Appeal gave it too much weight. They pointed out that challenging the notice wasn't purely a legal point. It involved a factual question. Was the Commission really satisfied about the water levels? That should have been explored at trial with evidence.
And the impact was mainly on these parties, not necessarily some massive public law issue affecting everyone.
That seemed to be their view. More importantly, they stressed the unfairness to the Coulton group. They'd won the trial fair and square on the issues presented, to then face, as the High Court put it, virtually a new trial on an entirely different issue years later on appeal that denied expedition, finality, and justice.
Justice Dean disagreed, though.
He did. He felt challenging the validity of a public notice was important enough, and that the oversight by Holcombe's team at trial shouldn't be an absolute bar. But he was in the minority.
So the High Court slammed the door shut on challenging the notice's initial validity within the Coulton v. Holcombe litigation itself. For Holcombe's group, in this specific fight, Justice Lusher's ruling stood. The notice was, for their purposes, a valid barrier.
That's the effect. A major victory for the Coulton group on the procedural principle, and it meant Holcombe's path to getting their application approved through this appeal was blocked.
But wait, there's more, right? The case went back to the Court of Appeal.
Yes. Holcombe's original appeal, on those first 17 grounds challenging Lusher J's findings about the application themselves, was still technically alive. But their big weapon challenging the notice had been taken away by the High Court.
So did they just argue those original points, or did they try something else, knowing Mr. Ellicott's persistence?
They tried something else. Undeterred, the Holcombe group, still represented by Mr. Ellicott QC and Mr. Craig, filed another motion in the Court of Appeal in 1988. This time, they wanted to add different new grounds.
Not the original validity again, surely.
No, these new grounds were based on things that had supposedly happened after Justice Lusher's trial back in 1984.
Okay, what were these new points?
Two main ones. Ground 18 argued that amendments made to the Water Act in 1983 or 1986 had effectively nullified the 1982's 20Y notice. Ground 19 argued the notice was irrelevant anyway because the Commission had apparently revoked it in the Government Gazette on November 13, 1987.
So arguing that even if the notice was valid back in 1984, later laws or actions had killed it off.
That was the idea. Mr. Ellicott argued the 1983 Act point was, admittedly, an oversight at trial, but the 1986 Act changes and the 1987 revocation. Those happened after the trial, so they couldn't possibly have been raised before Justice Lusher.
Who was hearing this application, and who are the parties now?
This motion came before Justice Allen in the Court of Appeal, with reasons published later, around May 1990. The parties were essentially the same Holcombe's group seeking the amendment, Coulton's group opposing it. The Water Administration Ministerial Corporation, the Commission's successor, was also involved, represented by the State Crown Solicitor, Mr. H.K. Roberts. Interestingly, Mr. Roberts also represented a new party in related proceedings, heard concurrently, Mark Alexander Holcombe.
Okay, so, third time lucky for adding new grounds. What did Justice Allen decide?
No. The Court of Appeal, with Justice Allen giving the lead judgment, again refused to allow Holcombe to amend their appeal.
Really? Even for the points based on events after the trial?
Even then. The reasoning was slightly different for each point. For the 1983 Act argument, the court said, nope, that act was in force at the time of the trial before Justice Lusher. You could have raised it then, you didn't. Too late now. They pointed to the costs and delay caused by not raising it earlier.
Standard bound by the conduct of your cases stuff again?
Pretty much. But for the 1986 Act and the 1987 revocation points, the post-trial events, the court took a different tack. They said allowing these points now, years after the trial, would be a gross injustice to the Coulton group.
Why injustice? If the notice was revoked, shouldn't that matter?
The court considered the long history. Coulton's side had defended the case based on Lusher J's findings for years. A significant chunk of that delay, the court noted, was due to Holcombe's own previous attempt to amend the appeal, the one the High Court shot down. To allow them to now rely on events that happened years after the trial, partly because of delays they contributed to, was just seen as too unfair.
So the message was, this specific piece of litigation, this appeal from Lusher J's 1984 decision, has to be decided based on the situation at that time, or at least arguments available then. Later changes are a separate issue.
Essentially, yes. Justice McHugh had actually hinted at this earlier. He'd suggested that if circumstances genuinely had changed because of the 1986 Act or the 1987 revocation, Holcombe's group might have grounds to start fresh proceedings in the Supreme Court, asking for Lusher J's original orders to be varied or discharged because of those new events.
But they couldn't just tack it onto this old appeal.
Exactly. You couldn't just bolt new arguments onto a case that was effectively about reviewing a decision made years earlier based on the facts and law known then.
So let's sum up this whole procedural journey for Coulton v. Holcombe. Holcombe's group tried to get their 1983 application treated as an amendment to a 1979 one. Lost a trial because the 1982 notice blocked new applications. Tried to challenge the notice's validity on appeal, got permission, but the High Court slapped that down based on procedural finality. Tried again to raise post-trial events, got knocked back again due to delay and prejudice.
That's a pretty good summary. In this specific litigation thread, they were ultimately unsuccessful. Justice Lusher's original orders, based on the premise, unchallenged at trial, that the 1982 notice was a valid barrier, remain undisturbed for them. They didn't get their water licenses approved via this particular legal fight.
It's a really stark illustration of that principle, isn't it? Bound by the conduct of your case.
Absolutely. It underscores how critical those early decisions are, what arguments to run, what evidence to present at trial. Appeals aren't generally do-overs. They're mostly about checking if the trial judge made mistakes based on what was put in front of them. Strategic choices, or even oversights early on, can lock you into an outcome years down the track.
But here's the kicker, the final twist you mentioned earlier. It involves that same judgment from Justice Allen in May 1990, where he refused Holcombe's last attempt to amend.
Yes. This is where it gets really interesting, and maybe a bit troubling from a justice perspective. Because Justice Allen was also hearing other related cases at the same time. One involved that new party, Mark Alexander Holcombe.
And presumably Mark Holcombe wasn't bound by the procedural history of the original Coulton v. Holcombe appeal. He could raise the validity of the 1982 notice.
Precisely. He wasn't bound by the way the original Holcombe group ran their case. So Justice Allen did get to consider the substantive validity of the 1982's 20Y notice in that related context.
What did he find?
He found that the notice, specifically the part covering the Severn River catchment that affected the Holcombe group, was invalid.
Invalid. After all that, why?
His reasoning was fascinating. He looked at the Commission's own documents from 1982. He found that when they calculated whether there was enough water, they'd wrongly included a huge amount, 26,000 megaliters tentatively set aside for applications that were just in the pipeline, including the Wallen Creek Association's proposed scheme.
So they counted the water the Holcombe group wanted as water that was already allocated to justify refusing new applications like Holcombe's. That sounds circular.
It does seem that way.
Yeah.
Justice Allen found that if you excluded that anticipated demand, the Commission's own figures showed a significant surplus of water in the Severn River source at the time they issued the notice.
Meaning the factual basis for the notice wasn't actually met.
Correct. Justice Allen concluded that no reasonable person looking at the actual data the Commission had could have been satisfied there wasn't enough water. Therefore, the legal condition for issuing the S-20Y notice wasn't met, and the notice for that area was invalid from the start.
Hold on. So the very notice that formed the entire basis for the Coulton group winning at trial, the notice the original Holcombe group was ultimately barred from challenging in their own case because of procedural rules, was eventually found by the same court in a parallel case to have been invalid all along.
That's the staggering irony of it. The administrative act that blocked them was fundamentally flawed. But because of the principles of finality, the way the litigation unfolded, and the delays involved, that specific group of litigants, the original Holcombe claimants, couldn't benefit from that finding within their own long-running case.
It's a powerful lesson. Coulton v. Holcombe shows that the legal process, the how you fight, can be utterly decisive, sometimes even more so than the underlying rightness or wrongness of the situation.
It really does. Even if a government action is later proven invalid, if you didn't challenge it correctly at the right time in your specific lawsuit, the door might be slammed shut for you because of these deep-rooted principles about bringing litigation to a close.
So we leave you, the listener, with this thought. We have this principle of finality in litigation. It promotes certainty, stops cases going on forever. But does it always serve justice in the broadest sense?
Yeah, think about it. If a genuinely invalid government notice stops one group because they made a procedural error years ago, but another group successfully challenges it, later does that create unequal outcomes based purely on legal strategy and timing? When does the need for finality potentially outweigh the need to correct a proven error by a public authority? It's something to ponder next time you hear about a complex case turning on what seems like a legal technicality. It's often much more than just that.